Ladies and gentlemen, a small announcement before we begin the session. The organizers have made arrangements for the esteemed delegates for use of the ropeway located nearby to the present venue, which will remain open till 6 p.m. for the delegates to enjoy the scenic view of Gangtok. Arrangements for visit to the orchidarium have also been arranged. You are invited to visit and experience its beauty. Help desks have also been set up outside the hall to assist the delegates with any queries. Ladies and gentlemen, the Honorable Chair, Co-Chair, Honorable Lordships, the panelists, and the moderators have arrived. I kindly request the organizers to accompany the Lordships to the dais. Honorable Lordships and my distinguished guests, we now begin session one of the technical sessions. The theme for the first session is Roadmap for Mandatory E-Filing. I now request Learned Registrar, High Court of Sikkim, Ms. Jyoti Kharka Ma'am, to kindly present the traditional Sikkimese Khada to the Chair, Honorable Mr. Justice J.K. Maheshwari, Judge, Supreme Court of India. To the co-chair, Honorable Mr. Justice Sandeep Mehta, Judge, Supreme Court of India. To the co-chair, Honorable Mr. Justice S.V. Bhatti, Judge, Supreme Court of India. I now request Learned Member Secretary, Sikkim State Legal Services Authority, Mrs. Shamita Sharma Ma'am, to kindly present the traditional Sikkimese Khada to the distinguished panelists. Honorable Mrs. Justice Anita Sumanth, Judge, High Court of Madras. Honorable Mr. Justice Saumitra Dayal Singh, Judge, High Court of Allahabad. Honorable Mr. Justice Mohamed, Judge, High Court of Kerala. I request Learned District Judge, Special Division 2, Gantok, Mrs. Jwala D. Thapa, ma'am, to kindly present the traditional Sikkimese Khada to the distinguished moderator, Honorable Justice Mr. Suraj Govindaraj, Judge, Karnataka High Court. I now humbly request Lordship to open this session as the moderator.
Good afternoon, everybody. We'll first start with the chair addressing the session.
Good afternoon, Brother Justice Sandeep Mehta, Brother Justice Bhatti, Sister Anita, Mohamed, Brother Saumitra Dayal, Govindaraj, and our technical team. If we look into the session and theme, then we find that what we are doing at present is only preparing a roadmap for mandatory filing. The word important is mandatory filing. I feel the organizers would have introduced this having some intention in their mind. At present, we go, filing is there, then same time, paper filing is also there. I thought the thought process may be until when we thought about e-court functioning and it should be paperless, then the first starting melting point would be that of mandatory e-filing. When there is no paper, it's only a e-filing, and after e-filing, e-scrutiny, then thereafter e-corrections, and everything is e, then there may not be any need for anything others. So this topic, I think, word mandatorily having significance of it. So once we go off it, and we thought, as I already said in an inaugural session, we have come from filing now to the e-courts working. So the thinking today is mandatory e-filing, how we should prepare a roadmap of it. For this purpose, as I think I give to this mic to Brother Justice Bhatti, who will have his own views on the subject. First, he will apprise you, then we'll proceed further. I request Brother Justice Bhatti to take up the mic and apprise all of us.
Distinguished guests, good afternoon. My elder brother, Justice Maheshwari, to make all of you become more alert from the relaxation we had during the sumptuous lunch session, has said, I am going to elaborate on the e-filing system. My journey with the e-filing system, etc., dates back to 2019, 2020, 21, 22, 23, till I was in Kerala High Court. After coming to Supreme Court, I have forgotten what is e-filing. Since this is a closed gathering, and I should also instill a little bit of alertness in the distinguished guests present in the hall, I must say I am here because Chief Justice Mushtaq called me. Chief Justice Mushtaq called me because he knows me when I was in Kerala. Not that I am an expert in this subject. Let me begin from that stage. Dear all, our all endeavors is to make the system more efficient, functional, and also achieve the object for which the efforts are joined together. For a while, I will keep myself away from the role of a Supreme Court judge, for that matter, Chief Justice of Kerala High Court, or a judge of that court and other courts also. I will keep myself as a person having ringside view of the circus or tamasha that would be going on in the courts. No one is interested to come to a court. No, sometimes respondents and defendants alone are invited to courts. But many a time, circumstances push them into litigation. I broadly categorize the understanding of litigation in this fashion. First, it is cause of action or a crime. These two situations will take a person to the counsel for his advice, guidance, and professional services. The professional does his bit. He brings the cause or the crime before the court. We have completed now 4 C's. These 4 C's have been in existence for quite some time. People continue to repose confidence in these 4 C's and the system is running. Now, what is the greatest effort we are making through, you call it e-filing, digitization, digitalization? This is beginning with again computer C. My expectation from this last C is to enhance the functional utility of rest of the 2 C's and give the best of the results for the first 2 C's. That is cause of action and the crime. Whenever we introduce these measures, my expectation is that there should be periodical audit on the performance and the result we derive from the procedures we put in place. When this being one of the suggestions I would like to give on this occasion, another suggestion I would like to leave for deliberation in this technical session is that there is no homogeneous approach in the country. What I suggest as co-chair in this session is, please mark the best of the practices that could be resolved, that could be informed to the Supreme Court committee, take their approval, and after it is tested and processed, the same is universally used in this country. Then the next challenge is how to make these measures user-friendly. Someone has asked me a question. That question I ask myself. Supreme Court, there is digitalization, everything. Still, I keep with me only the paper book. When I am discharging my duty with the help of a special petition paper book, it does not mean I am against most of the innovative procedures that are being put in place in the system. My answer to such people is, this is not an overnight revolution. It is nothing but a transformative evolution to strengthen the 4 C's I said. I request my other co-panelists to throw light on these aspects, which would finally enable the Sikkim High Court to prepare a draft document and send it to the Supreme Court for further distribution all over the country. I thank my brother Justice Mustak, the High Court of Sikkim, and the government for giving me this opportunity. Thank you. Thank you very much.
Taking back You have heard Mr. Bhatti. He has given 4 C's: caution, 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 caution. So he has not cautioned all of you, not I am. Remember one thing. And the next part is, it is the best, at least otherwise you will be bored. You will start doing something, pouring something in your mind, you know everything well. And the next part, he gave thanks to Mustaq. Nobody else. And you are cautioned. Anyway, it's not issue. Issue is what and what manner we have to prepare a roadmap for mandatory filing. I request Brother Justice Mehta, who is having much indulgence on the subject, and he will discuss and he will apprise everything to all of us. Please.
Thank you, Brother Justice Maheshwari Sahab, Brother Justice Bhatti. So I don't reserve my thanks to Justice Mushtaq at the end of the presentation. I will give the thanks right away. He knows very well that I am a total novice at this e-filing business. I've never had the occasion to be a part of the e-committee either in the High Court. So only little bit of touch I had when I got to discuss some things with Justice Sumanth while I was in Guwahati. But still, sincere thanks to Brother Justice Mushtaq for giving us this opportunity. What a glorious weather Sikkim has. Out of the sweltering heat in Delhi, you are in blissful weather. So my and of course AQI of 53.
Non-polluted
Yes, AQI 53. So when I was thinking that I being a total novice at the topic and I'll have to share the dais with such diggaj as Justice Maheshwari, Justice Bhatti, what should I say? Almost all of us are a part of this Indian High Court judges group. While we are discussing this roadmap, my feeling is that the biggest stakeholder is the lawyer. Are we asking him what is the impact of this mandatory filing on the way the lawyers used to make the presentations earlier and now they are doing it? So there was a very interesting, there's a very interesting blog by a lawyer who goes under the pseudonym that is Gobbledygook. I'll just read it out. And I shared it with the young lawyer, and his response is very interesting. That perhaps gives us many answers. I'll just read out, it'll take 2 minutes. So he starts with referring to one Honorable Chief Justice of India who introduced this e-filing business. Of course, it helped us, everyone, each court greatly in the COVID times. He says, the illogic in this direction of e-filing was simple. Why burden courts with mountains of paper when you can burden lawyers with mountains of expenses? It was the classic Mumbai Netas go to Shanghai movement. See spotless streets there, come back here and declare, from tomorrow, Mumbai will also be Shanghai. Except here, instead of clean streets, we got clean hard drives. Of course, the 1%, the elite class were thrilled. They already had the iPad styluses and probably assistants named Siri. The rest of the legal fraternity were mere mortals who still believed that the best way to turn a page was with a strategic lip on the fingertip. And then came the notifications. All pleadings must be filed online. Then the advocates on record struggled with the scanning. The cost of scanning jumped. But before they could move on, there was another direction, bookmarking. Well, the lawyers were, of course, in a state of disbelief. What is a bookmark? Bookmark is something we were used to put in the books when we went to sleep. Anyhow, they started looking at the softwares. The softwares are very expensive, the licenses. Then, as our Indian mentality is, we try to crack the software code, go for the pirated versions. But now comes the serious observation. All this had been done, and then comes the direction. Please also file hard copies. Now, with that direction, I would like to ask myself a question. Are we really going into paperless courts, or courts which really don't see the paper, but the paper gets on piled in the registry to be scrapped later? The idea, the basic idea behind this development was, of course, to make the filing simpler, easier, accessible to all. But if we are still going to rely on paper, and my next observation will be yes, we have to rely on paper. And I'll also give the reasoning behind that. But I shared it with a young lawyer, and his answer is interesting take, but overall, the benefits far outweigh the initial difficulties. Bookmarking is available for free on most softwares, and paid versions are not required. These get recognized on Adobe as well. Liquid text is not mandatory, it is for ease, but other linking documents are available. Undeniably, the cost of the Apple device is very tremendous, but there are other cheaper versions available. Online filing has made life ridiculously easy for litigants outside of Delhi. Now, this is the observation which we will have to ask. Outside of Delhi, are we only talking of Delhi or the entire country? Well, Justice Mushtaq has now started it in Sikkim. So, whether the litigants and the lawyers who are in the far flung districts do have the access to all these facilities. So, the life has become easy for litigants outside Delhi who would otherwise spend tons of money flying in and out to verify pleadings and then having physical notaries. Yes, that's true. That cost has indeed come down. One very interesting take is that photocopying, every time you went for photocopy, the cost was repeated. Scanning is one time. That's really interesting. So these are the few of the replies by the young lawyer. But now I would like to put my own viewpoint. When you are dealing with criminal matters in particular, whether e-filings would really serve the purpose. My experience, whatever little experience I've had working as a trial lawyer and then as a judge in this High Court and in the Supreme Court, that unless you are able to have a look at the original document in a criminal appeal, you would be really doing a great injustice. How do you meet this requirement in e-filing? That is perhaps what the new system will have to factor in. I'll share one single experience and then I'll close. We heard a matter wherein, in the Supreme Court, of course, wherein the accused had absconded. Proceedings under Section 299 were opened. And the argument of the lawyer before us was based on those scanned documents, scanned and translated documents. That look here, sir, 299 CRPC was never complied. As a matter of fact, it was simply the 161 CRPC statements which were exhibited. The witness was never called in the dock to testify. I was little taken aback. It was a case from a Sessions Court in Delhi. So it really didn't go down well with me. I thought that it's not possible. District judges, the session judges having had such great experience would not really let this lacuna creep into the trial. So I called for the original record. Because of course, just as we see the original records are totally torn papers, brown papers, taped. That all itself gives a feel of nostalgia. Finally, I got to that record. Every single statement had been recorded by the trial judge. It was taken under his own seal and signature. The witness had been summoned. His statement was recorded. Unfortunately, the same thing was not reflected in the translated copy of which the scanned version was presented to us. So this is the small challenge, which is a very substantive one, in my opinion. I'm posing to all the IT experts to answer that when we need to fall back upon the original documents, which we should in original trial cases, how do we deal with that? So that is a small observation I would like to make. And of course, the domain experts are here. They will probably consider my question and answer the same. Thank you.
Brother, as usual, Mr. Mehta has started that what's the real problem and how we are discussing of mandatory e-filing, how it can be successful. And in any case, we prepared this module, what is essentially required to be introduced therein. So mere filing is not sufficient. Wherefrom we are taking a record and we have to see those interfaces must also be equipped with this correct documents and thereby it should not be affected. I will put 4 points in which is essential probably at present. Then I will hand over to Govindaraj who will go for the discussion. 4 points is why we are discussing for mandatory e-filing module is number one, simplified, unified e-filing interface. Brother Mehta has pointed out that how the advocates and the lawyers can have acquaintance of everything until because they have to go for e-filing. I have discussed, I've seen from the Supreme Court. Supreme Court at present is dealing with two persons are sitting who were in the Supreme Court here. One is Justice Kalgaonkar and that Pushpa, who was from Madhya Pradesh eCommittee. I know this thing. 2.0 model we are using. Now we proceeded to 3.0 model. Now in this, so many problems have been removed. And what the Supreme Court is doing at present, 70 AORs have been given on the basis of the pilot project and experiencing this. Am I right, Mr. Mishra? Anjani Mishra? Yes. We have given this to them. Then what are the problems in this e-filing modules? And which 4 things which we want to introduce in those things is number one, simplified, unified e-filing interface. Number two, system generated consistency means mandatory filing must system generated dockets, then indices, then pagination, then third, data interoperability and this digital silos, and fourth is infrastructure strength, how this can be beared with, and last is storage of every data. So these are 4 things which I am saying this is very essential for everything. And now I will hand over the mic to Mr. Govindaraju who will go for the discussion. They are the domain experts and they have come from different high courts, all our 4 judges. I will say Dr. Anita Sumanth from Madras and Dr. Saumitra Dayal from Allahabad, Justice Mohamed CP from Kerala, and Govindaraju, you know, from Karnataka. They have let them discuss how they develop their e-filing modules, how far it is workable, what are the problems, and how we can it enhance it. So for that we are here. Thank you. I'm giving to Govindaraju, please.
Thank you, sir. All three of you have put the entire thing in perspective, different perspectives coming from three Supreme Court judges, which encapsulates everything. For the people in charge of the filing and decision making at the High Court, e-filing was spoken of as convenience for lawyers, as Justice Bhatti spoke of and Justice Mehta spoke of. Is there any interaction done with the lawyers to ascertain what they want? E-filing is also supposed to be a beneficial benefit.
It is required that you should little nearer to mic.
It is on, sir.
It is on.
E-filing, but the mic is not. E-filing is also supposed to be for the ordinary litigant to who could file the case from his place using e-Seva Kendra or Gramavans. How does mandatory e-filing change that person's experience, and what are the things that your respective courts have done to cater to this requirement? Mr. Singh, would you like to start?
See, at present, I guess when we started, we have all looked at the lawyers first because they are the stakeholder who come to bring the litigation to court. And per se, in fact, coming before to this conference, we checked that we are roughly having 2000 filings per day at Allahabad, but in person for the entire year, it's 366 in all. So of that, 50 or 60 have filed through E, only that much. So I would feel the feel that we should look at the scale, which is because they're both stakeholders. Yes, the lawyers exist for the other stakeholder, but if the litigant is going to come through the lawyer, then I think there is no harm in looking at the lawyer first and then engaging with the litigant. My personal thoughts on that is also that if we look at the litigant first for filing, then we may be overlooking the aspect of legal advice being rendered to him before he comes to court, which is an important filter for courts. Our efficiency depends on the accuracy of the pleadings, their responses, and the arguments. So at present, we have looked at that, but yes, litigants, when there are the educated class, especially because we are dealing with writ petitions mostly and proceedings intra-court appeals arising. In the criminal side, again, the litigant is already in jail, so he's not going to apply for bail on his own. He comes through either lawyer or through the legal aid in appeals as well. But yes, at present, that is how we are looking. There are difficulties which we are looking to solve because of the, I would again feel that we think paper and act E. So first we are requiring the document to be prepared partly because of our own compulsion that the annexures to the writ petition, they can't be Word documents always. So they have to be scanned. So you have a whole petition and then we scan it. So that paper involvement or is unavoidable. And that is the catch-22 situation that we face. What to do then? The other is then when it goes to court, how you move with the kind of workload that individual judges have and the ease and convenience. Because we are all products of the same society. We grew up writing letters to all our relatives, friends everywhere. Now writings have been replaced in the social space, many with the emails but formal work is still being done on paper. So if evidence is going to arise, it's likely it will be on paper. It's not easy to replicate at the present technological levels to say that, all right, this correspondence corresponds to this, the signature there's no way to verify unless you get the signature to the handwriting expert where the dispute arises. Yes, it doesn't arise in every case. Most documents get admitted in, especially in writ petitions. But those are the kinds of challenges I guess we should look at. First, the stakeholder is the lawyer. We should look to resolve all his issues, interact with him more. First, we have devised a measure which has worked well, all right. They're not complaining, but yes, to make it better, we should engage with them, get their response, and then move on.
Just Sumanth, any ideas on that?
Good afternoon to all of you. Thank you, Mushtaq, for this invitation for this wonderful conference. The first question that was posed was mandatory e-filing. I just want to emphasize and perhaps pause for a second on the word mandatory. And the reason why I do this is this. A few years ago, when we were trying in the initial phases of rolling out mandatory e-filing, we had an interaction with the bar. And the bar members looked at us and said, mandatory e-filing, how can you mandate it on us? You can't mandate it on us. So there are two schools of thoughts and perhaps two ways by which one would proceed. One is you take a tough stand and thrust it on them. You roll it out and you smoothen the processes along the way, and somewhere in due course of time, it happens. The second is you find out how best they can be eased into the system. And I think the Madras High Court has had experience in both. As far as the district is concerned, we have been very successful in rolling out e-filing. We're almost 100% there. And that is because we told our district judges, we want this done, we would like this done. We will give you support to the best extent possible in terms of providing the processes, obtaining the infrastructure and the resources from the state. When I say resources, human resources as well as other resources in terms of hardware, monetary resources, support systems, etc. But find your own ways of doing it. And the trick there perhaps is to give them an incentive in terms of this is a suggestion which we have made, which is still at the stage of the rules committee. But we want to include in their annual confidential report a column to say how many of them are tech savvy, how many of them have been able to implement e-filing in their courts. Once they know that this translates into something which is tangible, and the judges know that there is somebody is watching to see how successful you have been, that will make a difference. And so when we put this kind of a pressure, sorry, it's not a nice word, but persuade, thank you. The persuasiveness, quote unquote, on them, they rise to the occasion. What they did is some of the judges, this is the feedback that we get. They say, if your case is e-filed, we'll give you priority in the court. So they find ways to incentivize people to file. So as far as the districts go, we took this approach. As far as the High Court goes, we have not been very successful. Our e-filing is only about 10% mandatory. And there are difficulties in this. As Honorable Justice Mehta said, we insist that even though you e-file, you also give us a physical copy, which in fact defeats the entire purpose of it. Now, having said so, Madras High Court is poised well as far as e-filing is concerned. And I would like to share some statistics as on for the month of February 28 to 2026. Our total filings, both in the district court and in the high court, were 1,64,037. And out of the total number, the number of cases e-filed in the high court was 4,205 and in the district 70,257, making it a total of 74,462 out of 1,64,037. So that's a good figure. And in fact, the last month before this, we were top of the line. In February, I'm given to understand we have slipped to the second position. So we must be doing something right. Our IT registrar, Mr. A.S. Ravi, is here. And I would like to just introduce him to the August gathering here. And I would also like to thank him for having supported us with these statistics and all the other material that I have on hand. So as far as the High Court is concerned, we are still evolving the methods by which we could increase the 10% to a more respectable figure. And one thing that I would suggest is response time. If there is an issue that crops up in the course of e-filing, and if the registry brings it to that particular judge and says, as far as your portfolio is concerned, there was this difficulty, response time is very important. How soon the judge is able to understand the issue, escalate it. If the judge concerned is not tech savvy themselves, how soon they are able to understand, assimilate it, escalate it to the technical team or to the e-committee and find a resolution. That is key. That is for the first question.
Yes.
Good afternoon, everyone. As far as the Kerala High Court is concerned, from 2022 onwards, it is mandatory e-filing in the High Court and in the district judiciary from 23 onwards. Therefore, there is no choice.
Yes.
Just
Just I want to assist you. When this word mandatory was used by us in Kerala, what type of resistance
We did face.
we have received, how it has been gradually phased out. if at all it suits you, you may preface it with that.
Correct.
Because when we said mandatory, people have gone that far to say that my client has a right to come to Kerala High Court.
100%.
Who are you to tell me whether I should come by auto or car?
Correct.
Since it is Kerala, they put this question to me.
Correct.
I said, no, we will not say anything. You can come to Kerala High Court, whichever way you like. How we have provided incentives to the lawyers and also the litigant public, please tell. Then, even if we use the word mandatory, how it has been gradually eased out.
Correct. In fact, we did face a lot of objections from various quarters. All the stakeholders were consulted. They were taken into confidence. Though it was in phase, I only said from 22 onwards in the High Court and 23 onwards in the District Judiciary, it has been mandatory. And it's a High Court where 40,000 writ petitions are filed every year. There has been no reduction because e-filing was introduced. True, there were bottlenecks, there were problems. Even now, even at this stage, we are having a monthly meeting of the e-committee with the Advocate Association, with the Advocate Clerk, everybody. And their suggestions are taken, the periodical improvements are made, and incrementally. And today, there is no problem as such because this is getting on well. But only because all the stakeholders could be taken into confidence. And we thought it was a transition. And therefore, there will be some teething problems, glitches. They were taken care of, remedied. And today, across all jurisdictions, all categories, in both the High Court and in the District Court, it is mandatory e-filing.
Without backup paper filing?
No, physical papers are being filed. About e-filing, it is mandatory. That's all I said.
To keep them busy.
And today they will not be able to find out any other job other than doing the clerk's job. It's a social issue.
Anyway, as per the discussion you all have discussed, 2-3 things has come: trust, then ease to them, and third is incentivize. All thing. This is how we can brought into the picture all this mandatory e-filing, maybe a mode to make it easy, and the people must go on that. I have recently, we have to go in Madhya Pradesh High Court for inauguration on one software they have developed. What features they have developed therein, certain relevance as there, I'm putting of that because it may be useful for the purpose of preparation of the e-filing module. What they did is, suppose filing is there, here in Madhya Pradesh there is a change. What we take it when e-filing start, we have one sheet. In that sheet we fill up everything, and from that courts and everything we get every record from the trial court and everything. So automatic captures the district court appeal datas, everything. Second, automatic mapping of the subject matter of the roster listing. Even the cases would go for roster listing, that would be. Then automatic calculation of limitation period. This is a very normal. Then online defect notification. This is now the Supreme Court we have started. Then automatic fee calculation and payment. Unified access via bar, council and enrollment number. So they can get by that. And then the real-time case status update, and the free paperless registry operations started. And in this, they are connecting with the some police stations and everything. Suppose if bail application got listed, then the judges need not to have anything. You have a crime number, you push it, you can get it everything on your dashboard. So this is one of the features. If we develop like this, is one of the problem Brother Mehta has told, that the original scanning, the scanning which has been done, we don't know what is the scanning done. Now, if it's since beginning, if we start connecting of this, then there may be these are the issues. We can only say this much: when paper filing was started, e-filing module we have started in only in somewhere in 2004 we started e-court project. Now phase 3 is coming. We are on that. These problems would be there. How make it ease That we have to work out. And so far as incentive wise is concerned, when these processes is included, case is already automatically listed. They need not to go with anyone. It would be a ease for so many things. So we have to work out on this, but we have to go ahead to prepare how the e-filing module, which is universally acceptable, changing with the state wise some issues arising, that maybe can be done, and that may be done by the permission of the e-committee. And recently, Honorable the Chief Justice in the Chief Justice's conference has touched this issue, why we are preparing of the e-filing module universally. And Mustaq was also there. He spoke on that also. So all the Chief Justices are sitting here. They were aware of this. Now we have to proceed positive direction, positive thought, and we have to go ahead. Thank you.
One small observation on the lighter mode and yet very serious. We in India have the habit of using the James Bond style. Shoot first, think later. All of us are moving towards this paperless system. There are challenges which every one of us who works on the screen faces. The challenges with the eyes. Yesterday, I was with one of the judges in the Delhi High Court. He was carrying the now classically used hyaluronic acid preservative free eye drops. Every one of us, times to come, is going to face huge problem with our eyes, dryness particularly. So while we are developing this system, perhaps we need to migrate to some kind of hardware which would be easier on the eyes. If we start working on that right now, perhaps in times to come, our children, our successors will not curse us that yes, there are so many things. So we, while we are doing it side by side, we can think on that and also advise what can be the preventive measures. So same problem I'm facing, every one of us would be facing. Extreme dryness because of continuous watching the screens, not only this screen, but this screen also. But the preventive measures have to be taken. That was in a lighter vein, but still very serious issue which must be addressed. Thank you.
Brother has pointed out pollution. You know, we are in Sikkim, so we preparing a model where there should not be no pollution, but pollution would be there even for everything. Whenever we go on interface, internet, anywhere, it's a pollution is there. That is bound to happen, but how we can minimize it? That is the crux. And manage.
Minimize the harm.
Minimize the harm and manage it. Two things.
Though there are several problems that we have spoken of, one of the basic problems which is being spoken of or complained of by lawyers and litigants is as regards internet connectivity. Not being able to file it at the last moment on the last day of limitation, and or it getting rejected because the server is not working or he does not have the internet. The document getting rejected because it's not in the proper format. Document getting rejected because the size is more than 5 MB or 10 MB, whichever the high courts have fixed. Is there any training program that is resorted to by your respective courts for the lawyers and the filers, including the clerks and the litigants, to cater to this so that they can file it in a proper manner and it gets accepted by the registry, number one. Number two, if there is a rejection on account of internet because of limitation, is there any fallback mechanism that has been implemented which will accept the file even though filed 1 day later to be within limitation so that the litigant doesn't suffer? Any actions on these by your respective courts? Yes.
In fact, this is taken care of. Whenever there is a server downtime or a portal unavailability or a connectivity outage, our e-filing rules will exclude that type. And if it is restored, you can file it. It will be treated as a deemed valid institution so that the litigant is not in any way prejudiced for no fault of his. Because if we want the litigants or the lawyers or any stakeholder to believe in our system and they are acting on it, they can't be found fault when there is a trouble from our end. So this is taken care of under the e-filing rules in the Kerala High Court, which is framed by the Chief Justice under Article 229. And this is taken care of so that there is no litigant will suffer because of this.
Yes, Sumanth?
The filing is done through the e-Seva Kendras. We have about 315 e-Seva Kendras. We have people on hand to ensure that whatever are the difficulties that are there are quickly and efficiently gotten over. If they happen from private homes or offices, then if there is anything that is escalated to the level of the section, then yes, there are people in the section that can help them. In the district court complexes also, we have a team of assistants who will be able to assist them for any issues that arise.
There's a help desk kind of a
Yes.
system set
We've
up.
got kiosks.
Yours.
Kiosks.
Multi-level, you can say, but very simple. Help, providing for help at multiple levels. One is through audio-video measures that are available. Direct training to a limited extent. We have a very big bar and an even bigger number of clerks that who are there. A helpline mechanism is obviously in place, and not a single incident has been reported where any petition may have got rejected because it was time barred. Because we have a time stamping mechanism in place, so even a failed attempt gets time stamped. And once it is presented, once the stamp is available that it has been presented on such and such date, that's it. Period of limitation is taken care of. During COVID, everything was relaxed as everywhere, but barring that, not a single incident.
That's interesting. The very first time it's presented, the fact that it's presented gets date and time stamped. So irrespective of any faults, it's cured next. That could be one
And
of the ways.
even we have allowed,
Even if it is done later. Yes.
and so far as the file is concerned, it's not, it's stepwise filing, so he can save at every stage.
One other aspect which is spoken of is as regards how quickly is it registered and listed once it is e-filed. Of course, we spoke of incentives that if it is e-filed, it is listed the next day. But there, one of the issues that has come up is whether it is completely automatic listing or is it manual process of listing even after electronic filing. Have you, in all these three courts, implemented automatic listing? And if so, how have you done it so that we could share the best practices here? This is the thing.
So far as we are concerned, till the stage of when it says e-file, so the stamp report is what we call it. Once that is done, and that is also there's a program built, so it works on that. Once the report is clear, then there's nothing in the hands of any individual. It's all machine run. It will go up to filing and to the court. The issues that arise are up to filing, up to the defect removal, curing of defect. That is an issue. It's some issues that many things have been resolved, but yes, it needs, everybody needs an improvement. That needs an improvement because there is a, once you bring in a paper, the clerks were very used to it. No lawyer, mostly the petitions are not finally stitched up and placed before for reporting by lawyers. So that was always in the hands of the clerks. And some mistakes are clerk centric. So that is, I believe, where we have to improve and provide to ensure that if it is a defect free report, it will go in fast. And that is how we can, one of the ways we can incentivize e-filing. While saying that, yes, it is mandatory, moving towards that, not diluting that goal. But to incentivize would be easier because then once the matter reaches court early, there's nothing better for a lawyer or the client or the clerk or anybody. But yes, there are elements who don't want it to go very quickly.
Could self-assessment be done at the time of filing, or could a tool of machine defect finding, could that tool be made available
Yes.
publicly
Yes,
so
we
that
are
at the
exploring
time of
that.
filing they run through the process?
Very true. Very true. We are exploring that if we can provide a test report. You scan it, sitting in your office, you scan it, take a test report. Yes, of the lawyer.
It
We have
comes
a,
on the dashboard of the advocate who is filing, then he has to rectify those defects, and accordingly we can proceed further.
yes, that will be very valuable, and that will in fact solve the problem, incentivize it to the point that then it's a defect-free report petition always.
This is Sumanth in Madras.
Yes. So once it is filed, an e-filing number is generated, very akin to what Allahabad has. They have an e-filing number too, and that is at the stage prior to defects, which is done manually. The passing is done manually at the stage of which they look for defects. If anything is to be amended, corrected, that is done. That usually happens within 24 hours, and then an SR number, and then a number is given, serial register number, and then a number is given. At that stage, technically, the matter is ripe to be listed. Now, where it takes time is a scanning. That's where it takes time. So, normally, if I were to file a matter today, it would be ready to be listed tomorrow. But if it is a matter involving voluminous compilations, case law compilations, documents, etc., that is where it takes time. So if it is a matter where there is some urgency, then the council would make a mention before the court and ask for an out of turn listing slip. And the court normally obliges, if they are able to establish urgency, you issue the slip, which means that it gets put on a fast track. The matter gets put on a fast track, they scan it, complete it, and then bring it. So that's how the processes are. But our processes are quasi, they are not
completely automatic.
They are not
You still
completely.
have the hybrid model, which you
We have a hybrid model, and we have our passing officers who go through every paper.
In fact, I would just like to add, besides the e-filing, what we have done is started for the last 3 years is even physically filed files, fresh files. Those are scanned at the stage of filing, and they will all go available to the judges. That is perhaps being followed everywhere.
Just
Even
for the information of everybody, Allahabad does a scanning of nearly 30 lakh pages a day. It is something which is humongous. Probably if 30 lakh pages we do in Karnataka, we'll finish the entire digitization in 2 or 3 months. That is the scale that Allahabad is at. Of course, it is the largest high court, but kudos to the entire team. Yes, Niyaz?
In Kerala, if it is a defect-free filing, a number is assigned automatically and is listed. And if it is a bail application and a writ appeal, it is machine scrutiny. There is no human element involved at all. The machine scrutiny, it is numbered and sent up the very next day.
This we did touch upon. Once there's a digital filing, is it required that it is printed and placed before the judge? Or would the judge be dealing with the e-file document with a dashboard on with the judge? Is the same digital record also available to the lawyer, or does the lawyer carry the physical file into court? Are they all on the same page? Because it's not only the initial filing that I'm speaking of, it is subsequent filing, which we in Karnataka we have come up with a word called add-on. You file case laws, you file memos, you file applications, all those things. Again, how do they go about the digitization? And are they available on the dashboard of both the judge and the lawyer, so that the paperless is not only for the judge, paperless could also be for the lawyer not carrying paper into the court. Is this journey going ahead? How far has it gone? Indexing also, sir.
Indexing till final hearing.
Till final hearings. Because the case is not one stage, it comes before us for so many times. Normally when we say it is final hearing is what we take it up, but during the process of the case journey, there's so many things which keep on happening. How does that cater to? And does the lawyer have to carry the file, or does he have everything? The other most important thing was about the digital evidence and electronic documents. Large volumes, call detail records, financial statements, they're all presented without proper indexing. Is there a search capability which is there? Is any software being used so that there could be a questioning made of those documents to do a proper summarization? Are you using AI for the purpose of digital evidence and electronic documentation and during the course of final hearing? This is Niyaz.
Yes, we have in fact our in-house team has developed an AI chatbot, which will help us in summarizing the documents and also in handling the large volume like call data record running to pages or a 300-page contract. You can get it summarized. You can get detailed events. All this is done. This will substantially reduce the time.
This
See, as far as AI is concerned, our team has developed a couple of softwares. We have not been able to integrate it as yet because they are pending approvals at various stages. One is called an integrated bail management system, which has various facets of bail hearings and how it would go from filing of the bail application right up to the time the bail order is issued. We want to integrate it with the jails and the police stations. Now, in fact, we have developed that module which is pending before the Honorable Supreme Court eCommittee for its approval. The second module that has been developed by us is for an
Software. We also, Ratan also has done it. And MP has also done it.
Recently, what has happened, I will apprise for that. One matter from Uttar Pradesh came before us, wherein we found, with an order of the division bench of the Uttar Pradesh High Court, that if a person whose application for premature release or probation is pending since more than 6 months, they be released automatically. Mischief played was that in those cases, a person who is of 2 year, 2.5 year, 3 year, 4 year, they applied for, and their applications period has spent 6 months. Finally, in terms of the direction of the division bench, so many prisoners have been left without completing even the minimum max period prescribed for that. So this matter came to the attention of the Court of Supreme Court. In the meantime, the full bench of the Allahabad High Court passed a judgment. No, this cannot be done, and this judgment of the division bench is incorrect. But even then, what happened? The people who have been released that have not been brought back to the jail, either they absconded or they have not been brought back to the jail. So now in that situation, we called some NIC and everyone. Then we have developed for those purpose, particularly for premature release, a software ought to be developed wherein if a person, as per in terms of the policy, every state do have a different policies. So in terms of those policies, a state-wide module must be prepared, and that must be connected with the e-prison module. How many prisoners are there? They completed that period, data is available. Then it should be processed from the office of the deputy jailer and it's reached to the stage of, so complete mechanism automatic provided, and it would start 6 months prior. So UP completed, Madhya Pradesh I called, so Madhya Pradesh completed. So now probably it will be done. This is one of the automation in that field.
I think we are running out of time. One last question is what I'm told. One of the reason the rule book gets thrown at us for any of the initiatives which are taken. The rules do not provide for this. The rules do not provide for it. If you do this, it will be contrary to the rule. Are there any amendments that you have made to the rules or proposing to make to the rules so that they can be made and e-friendly? And these all the things that we have spoken of now could be catered to with the rules helping them rather than hindering them. Just a thing.
That's a constant process being undertaken, mostly largely because of the initiatives of the committee, Supreme Court. So wherever provisions have been, wherever measures have been adopted, yes, rules have been amended. But it's like building a bridge when you cross a river. So once we reach that, as we are developing, it will remain a constantly evolving state. Because even what the infrastructure that we have today, certainly it's not going to survive another 10 years. So again, the rule will require change. So that is really not bothering us because wherever we reach, the rules haven't hindered us anywhere. Wherever we have wanted to do, we have amended and provided.
Now we can put some good suggestions if all judges are here from various high court. They can give good suggestions or good practices that can be taken note of. And if uh, kindly give, please, kindly give mic there. The judges want to say something.
Organizers, please
Anybody,
provide the
please
mics to the lordship.
raise some hand, please call.
Mics are on the tables.
Yes, sir.
Am I audible, sir?
Yes, you are
I'm
audible.
Mantha from Calcutta High
More
Court.
than audible, sir.
Sir. uh, Two issues I just want to, in fact, all three of your lordships from the Supreme Court have pointed out the need for a physical copy along with a mandatory e-filing. It should be considered a temporary phase to ensure on a long-term basis that the physical filing will gradually be phased out. So that is one part of it. The second part of it is in the context of a criminal appeal hearing last week that we were conducting at the Jalpaiguri Circuit Bench of the Calcutta High Court. The charge was under 376 of the IPC, of the former IPC. The medical report that was shown to placed before the trial court, or the trial court said this document has gone in unobjected. Whereas we found the medical examiner of the victim was not brought on as a witness to prove that medical evidence. And we later found when we examined the trial court records that there was an objection recorded in red ink. So the trial judge missed it out. We found it, and of course, there was other corroborative evidence for that medical report that was different. Now we had to look at the actual trial court records. So my first suggestion would be that along all trial court original records should be scanned and be made available. This will avoid delays in bringing the trial court records, which we find in many cases. Even cases filed in 2012, sir, some trial court records have not come into the High Court. This is one part of it, sir. Along with the
Brother, we have understand.
Sir.
Brother, we have understand.
And one more problem, sir, just one more, translations. Translations are a serious issue in the trial courts. The English language is not something we clearly understand. We don't know what to say. We say something else.
Brother,
Something else is understood.
May I
Sir.
suggest you one thing? At present, we have to discuss certainly a roadmap for mandatory e-filing.
Sir.
These are the practical problems when we are hearing the cases. We are not saying these problems are not genuine. These problems are genuine, but we have to thought that at this stage, when we are going for mandatory e-filing, what may be an essential required for which, and can we fulfill those here at the stage of e-filing? Therefore, this problem may not arise. So your problem has been, I think, taken note of. Just
One more addition, sir.
So
Small
that can be
addition.
put in.
Small addition, sir. Along with the Sir, small addition along with
Yes,
the
sir. Yes,
original scanned copy of the record. The translation and the original must also find place in the High Court records.
Sir, we are facing
We are
this
only-
problem every day in a Supreme Court every time. So
This is
sometimes we
this is
call the
only-
original record.
Only a
So
suggestion.
this
to the-
problem we are saying this mandatory e-filing we are discussing now. Prior to that, e-filing was there. So now mandatory. So once we go from e-filing to mandatory, and prior to that, filing was there on papers. So we have to thought 100 year. Now we have to eliminate this.
It's a gradual process.
Only thing is what we are discussing for mandatory e-filing at this stage. What niceties we should include, thereby this module can be betterly served to general public, advocate, and everyone. So this is our thought process, sir.
One small suggestion, sir.
One suggestion, madam.
One small suggestion, if Lordship's permit. Lordship, the submission is that in Rajasthan, we have done it in little bit phased manner. Like 22, we said central government advocates should do. 23, we said all state government should do. 23 and we said that all division benches should do. Division bench filing should be filing. So if it happens in a phased manner, in addition to what the Dayal has said, in addition to that, if you do it in a phased manner, then it will be easy to persuade the lawyers. Thank you.
Yes, my lord, advocates are opposing, my lord. We have already, I pointed out in
Number
four
one, my lord.
issues.
Number two, my lord, we are giving
Infrastructural strength,
number two, my
meaning thereby capable of 40 Gbps throughput. Until this is there, we are already set. We are having this issue. But
ma'am.
this is an infrastructure. We
Another
are
mal-
preparing a roadmap for e-filing.
Yes, another, my lord. Another, my lord, we are giving free scanning to the councils, my lord. Free scanning through e-Seva Kendra, my lord, we are giving to the councils, my lord. Previously, we are giving e-filing also, we have done, my lord. Now e-filing has been gradually stopped, my lord.
The basic thing is, if judges are ready to do it with paper, then gradually this will come into place.
Right. Yes, Mr.
Can I share two experiences, sir? First is of Supreme Court of India. When this e-filing started in Supreme Court, there was resentment among the members of the bar and also the lawyer clerks because it related to their employment. So the Supreme Court started to educate the lawyer clerks first. 450 lawyer clerks were educated how to e-file that. They were given good lunch. They were very happy. then thereafter, sir, the Supreme Court provided them a space along with the computers to sit there and upload their e-filing. First, and other incentives, sir. The other incentive was it was mandatory to file 3 copies of every petition, which was reduced to 1 copy. Then thereafter, the Supreme Court took the burden of that printing that 1 copy also. When the printing charges were 1 rupees 50 pice per page, which was reduced to 75 per page, 75 paisa per page. So gradually,
You told me at that time when I
yeah.
was.
And one more thing I wish to bring to your notice, sir. We are talking about e-filing. What we are doing, sir, they are typing the petition on their computers, taking a printout. They are bringing the printout to the registry. Registry is scanning that, and thereafter the e-filing process. So we are not moving toward digitalization, as Justice Mushtaq had said. We are simply moving towards digitization.
Digitization.
Paper is scanned and we are saying that we have started e-filing. This is not e-filing, sir. E-filing should be
You are right.
digitalized e-filing.
You're right.
That's it. Thank you.
May I tell you one experience?
Can I
Instead
just,
of it,
can I
yes.
just add one line? In fact, we should have a kind of forms. Like for SLP, what is the form? For appeals, what is the form? They should type straightway on the form. Maybe XML or some, we have many kind of forms. And then they could be taken into the system and automatic scrutiny, etc. That is e-filing. This is scanning and all this business.
That I am saying that Madhya Pradesh, it is started long back. He is also
Yes,
aware of
and
this
one
thing.
one more, we could sensitize those lawyer clerks. In fact, it's not taking their livelihood. They may be channelized to some other kind of work. Somebody has to look after those systems as well. Thank you.
May I tell you one experience? When COVID came in 2019-20, I was the Chief Justice of the Andhra Pradesh at that time. The peoples were suffering, filing were not possible. The staff was scarcity. I was 1,000 in place of 1,000. I was having 300 only. Then at that time, the Andhra is technologically very sound. I called some persons, and within 2 days, 3 days, they prepare the module for e-filing. At that time, our judges, and the Andhra judges, I gave the access to them, Zoom meetings, how you have to file. So the situation arose, filing started. So 2 things. One is trusting as came, not going on trusting. Trusting must be as contended by brother judge that if judges start working, it will come. It would not be a trusting with condition, automatic. One thing. Second thing, ease. Make it ease them. And third is incentivize. So these are the implementation processes. First, we have to go by mandatory e-filing module. So we have to discuss mandatory e-filing module. What is essentially ingredients we should brought in, thereby this may be successful for digitization. Thank you.
In Bihar, we have started 100% e-filing in all the district courts from today. For this, yes. for this we were preparing for last 2 months. What we did, we organized camps and we encouraged the lawyers to get themselves registered on the portal. So we kept on motivating them. During 2 months, we got grand success in persuading the lawyers in getting themselves registered. So the decks were cleared, and from today we made it 100% mandatory. In High Court, there is already 100% mandatory, and in High Court, two courts presently, the Honorable Chief Justice and myself, two courts, division benches, we are doing paperless courts. So we are on way.
Thank you.
Doing this.
Thank you. Can we
Sir,
close it?
we have to just submit one thing about the mandatory part. We in Gujarat High Court, we are coming out with our own e-filing software and paperless software. So before going with that, we called meetings with all the stakeholders, the lawyers, the advocate clerks, government officers, and I'm very happy to say that all of the stakeholders are now on board with us. It is mandatory, but voluntarily mandatory.
Thank you. Thank you. What?
So we have one last discussion.
Yes. He is the expert man.
So, Lordship, I will share my views. Honorable Chair, Honorable Co-Chairs, distinguished dignitaries on the dais and off the dais, and respected participants, a very good afternoon to all. After enriching myself with insightful views shared by Honorable Chair and the distinguished panel, I will keep my part very short. We observe that the nature of our discussion has changed. We are no longer reviewing how e-filing will be rolled out. We are now reviewing the present by asking how well does it work? And more importantly, how can we make it better? At present, we are in the transition phase. We have the system, we have the software, and we have the intent. But effective implementation of e-filing still require careful alignment with ground realities. As Chair pointed out, that one of the most practical concern is that even today after e-filing, physical copies are required to be submitted before the registry for listing of matter in many high courts. A lawyer who is one of the most important stakeholder in the justice dispensation system has concern. If a physical file has to be prepared, why go through the additional effort of electronic filing? Why is not in, what is it for it? Similarly, there are issues related to the submission of the original documents in certain e-filed cases. At the stage of exhibiting the evidences, original copies are required to be produced before the court. Therefore, our rules must be clearly addressed and when and how such documents are to be submitted. We also need to examine whether in civil cases we can dispense with the requirement despite the CPC mandating the physical production of the document. This brings me to the point that technology alone cannot bring the reform in the Indian judiciary. The real reform lies in our processes. I would like to suggest a few suggestions for promoting, which was, it's a reiteration of the facts only. Identification of certain categories of cases where e-filing can be made mandatory, especially on the matters where the government is a party. Honorable Chair pointed out that incentivizing advocates whose case is filed through e-filing. Early listing can be another option. Creating awareness for e-filing through e-Seva Kendra to the advocates as well as litigants. Developing the user-friendly interfaces that is very simple and easy to operate. So I will just point out that the vision which eCommittee is envisioning. The vision of the eCommittee under the leadership of the Honorable Justice Vikram Nath and Honorable Justice Anjani Kumar Mishra is to focus on judicial process re-engineering so that the existing rules, acts and workflow can be revisited and aligned with the technological advancement. Rules are blueprint of the software development. Moreover, the vision is to move toward automation, where it is related to the extraction of the metadata from the PDFs, automatic communication of the defect at the time of the filing, and reducing human intervention in registry processes like scrutiny and listing to promote efficiency. Before I conclude, I would like to thank Honorable Justice A. Mustaq, Chief Justice of Sikkim, for organizing this conference and bringing us all together for this meaningful discussion. Conferences like this are important because they all allow us only to share our successes, but also to openly discuss the challenges we have faced in the implementation. It's a wonderful opportunity to understand the underlying issues and to work toward a future-ready judiciary. Thank you.
Thank you. While closing, I will say that nothing is more powerful than an idea. Nothing is more powerful than an idea, and this time has now come. Thank you very much.
Thank you, Lordships, and the dais and distinguished guests for this thought-provoking and insightful session. We will now have a 15-minute tea break. The organizers are requested to escort all the distinguished guests for the tea break.